We'll go now to proponents. Proponents for HB 323.
Mr. Chairman, members of the committee, Eric Feaver, the head of MFPE, the Montana Federation of Public Employees. Actually, my job is president, and I'm elected to this position every 2 years, and so long as the members support me, they'll elect me. At least that's been the case for 36 years. And so I stand in support of House Bill 323 as amended in the Senate, in the House committee, and then in the House. I agree with nearly everything that Representative Tashida has said in regard to this bill. It is a codification of the Janus decision handed down by the U.S. Supreme Court in June of last year, and it is fully implemented. And the representative is correct. You can adopt this bill or not, and the Janus decision still stands and controls Montana labor behavior. So there is nothing here that's absolutely necessary, but from our point of view, it actually cleans up the code, and to simply adopt the bill as you see it in front of you will do that. And of course, it doesn't matter. In public employment, employees have the right to opt in and the right to opt out. And the opt-out provisions are under some if you want, judicial challenge around the nation, but not here in Montana, and we believe they will stand any test of time in the judiciary. So we do support the codification of Janus in House Bill 323, and we urge your support of this legislation exactly as you see it. And so I guess I'm urging that you not try any amendments on this bill. We've already done that, and so I think it's done right where it should be. So thank you very much.
Thank you. For the proponents, let me ask you this. Mr. Feaver, I have a couple questions for you.
Mr. Chairman.
Mr. Feaver, I guess I'm kind of curious how this works now in practice. I mean, as I understand it, the Janus decision says that you can't force a person to pay what are called, am I correct, agency fees, or the fees that are associated with bargaining. So how do people now kind of opt in, opt out of paying these fees? What's the process that's going to be now?
Mr. Chairman, the Janus decision said there's no such thing any longer as fair share representation fee or agency fee. The law for 40 years, which was also in Montana Code, permitted unions to bargain at the table a fee for services for someone who did not want to join the union. That fee was typically less than dues. There are now no agency fees authorized under law, and no contracts, whether they have that language in them or not, are enforceable. So nobody now is paying a fee for services by the union, period. Dues are another matter, and the Janus decision had nothing to do with members who were paying dues. I know there's some folks that think it did, but it didn't. And of course, folks can argue about this matter, but the fact is members sign membership authorizations. The authorizations state that you are a member until you resign, and there is a resignation period on the face of, for instance, in our union, on the face of the membership authorization you sign, there is a resignation period that says you can sign at any time during any day in September of any year. And we honor those resignations when they occur.
Okay, so I want to make sure I follow up here. If my memory serves me correct, well, you and my mom, for example, worked together many years ago in the Helena School District. But if I recall, she told me, and this is just correct, she did not have to become a member of the union, but she still had to pay the agency fee. So if I'm correct, you never had to be a member of the public union. You still had to pay the agency fee. What all this does is nullify the agency fee. Is that the correct summary here?
Mr. Chairman, that is correct. Your mother never had to be a member of our union or any public employee union, nor did anybody else who did not want to be a member. There's no such thing, and never has been, coerced membership. And even in some cases across our state, we have 400 bargaining units. They all did not have agency fee provisions. And so there are a number of our bargaining units where there was never such thing as a fee for service or agency fee, because you had to negotiate that with each employer, one employer after another. After 40 years, we'd bargain a lot of agency fee provisions in state government, university systems, school districts, and local governments. And so, I mean, they're pretty common, but they aren't everywhere. And now today, none of those provisions that pertain to a fee for union services is lawful, and so we don't enforce them, and we can't enforce them. We are now, however, asking folks who used to pay fees, would you like to join your union? And believe it or not, some are doing that.
So the next question I want to ask is how do you set the opt-in period for the fees or dues? Is that something that's created in law, or is that just something that you, the union, decides when people can opt in or opt out?
Mr. Chairman, that is the union's decision, and that has been upheld, in fact, by the Montana Board of Personnel Appeals way back in 1988, that unions in Montana may, in fact, establish resignation periods of time. They vary from union to union. The old MEA MFT, before we merged with MPEA, had a membership resignation period of August 1 to September 30. We have shrunk that to September. AFSCME, which was the definitive in Janus v. AFSCME, has a membership period that is a year after, well, I think it's 11 months after your initial enrollment. And so the periods will vary. The important thing for unions to do is that they must have an established period. It can't be something nebulous, and that they enforce that period. If a member during the resignation period says, I'm resigning membership of the union, please stop any dues payment, the unions are compelled to do that.
Okay, and then how does a member, a union member, know when the opt-in period is? Is that something that comes initially when they join the union, or how does a person go about finding that information?
In our union, and it has always been true, you must, when you sign your membership authorization, in fact, our form right now has your signature right below a statement that says, this is a continuing membership authorization. If you choose to resign from your union, you may do so any day in September. And you do that by emailing or writing the president of the union.
Okay. Senator Boland.
Thank you, Mr. Chairman. For Mr. Feaver, excuse me, Mr. Chairman, Mr. Feaver, can you tell me say somebody's in the union now and they decide they want to opt out. What are your obligations to that employee as far as benefits and?
Mr. Chairman, Senator Boland, first, we'll see if they're trying to opt out during the resignation period. And if they are not opting out during the resignation period, we tell them they cannot opt out until the resignation period. And we do inform them that, and we keep a record of that. And usually somebody wants to resign, they'll remember the resignation period too. And so they will inform us when that time comes. Our obligation to members and non-members where we have a bargaining unit are the same, which is exactly why agency fee. I mean, way back in 1977, the Supreme Court thought it was a good idea to charge an agency fee for folks that receive the services a union provides for collective bargaining, salaries, fringe benefits, working conditions, the things that unions do for its members. The more recent Supreme Court has decided, well, that's coerced speech, and so it's a violation of the First Amendment, and so you can't compel somebody to pay for union services. That's really the difference between, one Supreme Court from another 40 years removed. So we complied with the law for 40 some odd years, and we will comply the law until such time as in the future the Supreme Court changes its mind.
May I have a follow-up, please?
Follow-up.
Thank you, Mr. Chairman. Mr. Feaver. So if they are not paying any union dues at all, they're still eligible to have retirement. They're still eligible to have wage increases if there are some coming in, insurance.
Mr. Chairman, Senator Boland, retirement is a matter of statute. I mean, public employees are in retirement systems pursuant to what job they hold. Teachers are in the teachers' retirement system. Most state employees are in the public employees' retirement system. Game wardens are in the game warden system and that sort of thing. As a union, we work really hard to protect those things, and I think Senator Brown knows this very well, that one of the things that a union does is try to secure those retirement pensions and make sure they are safe and actuarially funded. And we've spent a lot of time in legislatures past and likely in the future to see that that continues. So that's a service the union provides to somebody, even though it's not a union retirement per se, if you look at it that way. When it comes to salaries and fringe benefits like health insurance, which would be a primary one, that's what unions do at the bargaining table. And those benefits, salary and health care benefits, accrue to non-member as well as member.
I had another one and I just lost it for a second. I'll get back to you.
Mr. Feaver, let me ask you a question. Maybe this is for my own education. As I understand it, in the private sector, when you have a union in your business, for example, everybody has to join it. Why is it that in the public sector we require these agency fees? Or maybe I guess I'm wrong. Correct me if I'm wrong.
Mr. Chairman, legislatures like to dibble around in the public sector, not so much in the private sector. I suppose someday maybe somebody will bring a bill to this legislature to impose right-to-work provisions on private sector unions. There will be a room full of private sector unions to visit with you about that at that time. But the Supreme Court decision only dealt with public sector employees.
Okay, so I guess the answer to it is that the legislature has codified more or less the ability of a public sector employee to join a union or not. That would be the answer.
Mr. Chairman, correct. Title 39 of the Montana Code is all about public employee labor unions.
Okay, that sounds good. Any further questions? Senator Boland has a question.
Light bulb. Thank you, Mr. Chairman, Mr. Feaver. Can you tell me, I'm still kind of fuzzy on the insurance part. So if you have been a member of the union and you have their insurance, can they also come in and say, if they decide to leave the union, not pay the dues, can they just decide they do not want to have your health insurance premiums and buy it elsewhere, or how does that work?
Mr. Chairman or Senator Boland, I think you might be in part conflating a private sector union with a public union, and I'm pretty sure you are, but let's step away from that. Some private sector unions have their own insurance, health, and welfare plans. And you probably want to stay a member or you will likely lose those health and welfare plans. But I'm not sure how you would ever do that because membership is pretty much a function of the benefits you receive from that plan. That's not true in the public sector. So when we bargain for teachers at the bargaining table or we bargain for state employees, as we do, frankly, in pre-budget negotiations for the folks who work for you, those health care benefits, in this case the premium the state pays, the co-pays and deducts that are provided in the state insurance plan accrue to every person who works in the state, regardless of whether they're a member or not. In fact, they accrue to all the administrators and supervisors that tell us what to do. And so, it's not like somehow or another you can, if you choose not to be a member, you lose your rights to benefits that we bargain. You don't.
Okay, and Mr. Chairman, may I have a question for someone else, please?
Yes.
For the sponsor, please.
Senator Malik.
Thank you, Mr. Chairman. I guess for Mr. Feaver, please. Mr. Chairman, Mr. Feaver, I can't help but think about Citizens United and a corporation's right to be an individual, and I'm working for that union, or I'm working for that corporation, and they're speaking as an individual against my interests. For instance, clean water or, upgrading the sewer system or whatever. Do I have any right, freedom of speech, to do anything about that, to protest their use of the money that they're making out of my labor to try to enact legislation?
Mr. Chairman, Senator Malik, you may be just getting to the core of why the Janus decision. The Supreme Court felt that an agency fee payer was not a member. But when a union would propose a certain item or oppose something, that member or that non-member felt like that was an abuse of their First Amendment right to speech. If you are a member, however, you are presumptively letting the union speak for you. And if you don't like that, there are two things you can do. Number one, you can resign during the resignation period, or you can do what a whole lot of members do. You can run for office within the union. You can come to our representative assembly. You can stand up on the floor of the representative assembly and move whatever your objection is into a new business item or resolution. You can elect people other than me to be your representative. And that's available to every member. Non-members, however, do not have that right to take an active role in the union itself.
Okay. Mr. Chairman, could I re-refer that to the sponsor,